Allen versus MM, ZAGP, Johannesburg High Court, 325. Norco J and Opperman and Wilson J concurring, 28 March 2024, bundle page 116 to 132, summary page 13. Now, this was an interesting matter. The judgment is against a Rule 42.1, which was a variation of a court order. Essentially, what happened is the parties were divorced. They agreed that the accrual would be divided. There would be an accrual payout. The original order determined the accrual to be 3.03 million odd. Then the respondent in this appeal went and had a crack at amending the order based on what they say were alleged errors in valuation and calculations. This was heard by Meyer Frawley J, and the amount was amended to 5.5 million, a good 2.3 bar extra in terms of the accrual payment. The appellant challenges the amendment or the variation which was granted, saying that it improperly alters the substance of the initial judgment, and that the party who was claiming the accrual wanted the increase or the variation should have proceeded on an appeal. The appeal was dismissed. The court essentially found that Rule 42.1b was applicable, process was followed correctly, and the accrual amount was rectified. For 2.5 bar, can we expect these parties to go to the SCA? Potentially. Let's watch this space. The ratio of the court, paragraph 48, the rectification does not take away the substance of the judgment, as the amounts are derived from the evidence and the record before the court, bearing in mind, as stated in West Rand Estate case, that the addition of interest erroneously omitted could be added in terms of Rule 42.1. As such, in this case, the value of the remainder of the party's assets as captured in Mr. Getz's report was left out. This was not adding extrinsic evidence to contradict, vary, or qualify the judgment. It was extrinsic evidence the appellant referred to, where it was held that if there is any uncertainty in extrinsic circumstances leading up to the court's granting an order may be investigated and regarded it in order to clarify it. Based on the foregoing, it follows that the court did not err in its adjudication. It is tried that the appeal court may interfere with the judgment of the court where it has been demonstrated that the court has misdirected itself. So the court did not misdirect himself according to the full bench, and the appeal was then found to be meritless.